Alex here with part 47 of the My Docket series on child custody and visitation. As with my previous videos, I'm going to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. And that's because my access parental rights have been terminated. Number two, the purpose of the series is to provide my viewers with one large example of my 8-year-long high conflict child custody ordeal from beginning to end in chronological order. We move on with this video into a sort of, I guess you could say odd piece of paper out. It's not going to be a very long video. It's a piece of paper that I couldn't fit in to the previous video on, this sort of thread with regards to the motion to set a procedure for setting appointments, non-emergency appointments. And at the same time, I didn't want to lump this video into the next one on this thread, which is going to actually be the hearing itself, the review hearing. So as I mentioned, pretty short video. We're only going to go over my review hearing statement. One of the things I'll go ahead and mention now before I even go into it is in my review of the rules don't appear to indicate that I even needed to file this document. And the reason that I filed it probably just had to do with the fact that I'd seen other similar types of statements being filed in the case. For example, we have the case management conference statement, and we also had the settlement conference statement. So based on me having had to file those two statements, I probably at the time assumed that I would need to file some kind of similar statement. And if I remember correctly, the first time I encountered this, I actually didn't file one, or I didn't know I had to file one. And so I wouldn't be surprised if I was sort of anxious about it, not knowing what I was supposed to do. And so let's just err on the side of caution and file this piece of paper. But I've reviewed the rules. I don't see anything in the rules that indicated anything needed to be filed. My ex's attorney sure didn't file anything. We just, she just went to court and argued. And I'm going to go ahead and just reiterate now that it's a good idea to check your local rules. I'm sure at the time I didn't really know there was an online place that I could look at these local rules. But check your local rules, because that's where you're going to find out whether or not something like this even needs to be filed in the first place. Just to rattle off the three circumstances that I do know statements need to be filed are two of them I already mentioned, the case management conference and settlement conference. The third one that I am certain they are required in is trials. And I think they just call them like a pretrial memorandum. And it would make sense evidentiary hearings would either require them or allow them, one or the two, because it's, for the most part, it's almost the exact same thing as a trial. It's just that, well, there's no jury involved. That's one thing. If we're going to compare what's the possible thing that could come up in a trial that doesn't come up in an evidentiary hearing, that's one of the things as a jury. And the other thing is to just sort of match up things that they have in common is the court takes evidence. The court takes evidence at those hearings, and the court doesn't take evidence at any other type of hearing. And what I mean by evidence is not just documentation and photographs, but also a testimony, like by a witness. So at this point, we can actually just go ahead and go into what I have filed. Here we have my review hearing statement. I'm going to go ahead and scroll down. First paragraph, I identify myself and I indicate to the court that I am appearing in proper person and that I am filing this statement with regards to the hearing that's coming up on February 23rd, 2009, of course. Wait a minute. 2010. Oops. Well, it happens. It happens sometimes when you just get so stuck in the last year and you kind of forget to update it. Now, of course, we're one whole month in, but anyway, I did want to pause and mention that that's a mistake there. That's for a 2010 February 23rd hearing. And yes, we are at this point, as of this filing, and maybe even the one In the previous video, we're into 2010. So, statement of claimed facts. Okay, this is something that is outlined. Maybe it's outlined in the rules, or maybe I pulled it off of one of those self-help forums. It could just be that I pulled it off a forum. But I do know that when you look at the rules that cover filing of statements, they typically do require things like this. Like, you need to identify the facts that you're claiming. You need to identify the facts that you and your ex agree to. You need to identify the law and all of that. It just jumps out at me as an actual thing that's supposed to be in a statement. So I just wanted to point that out to my viewers. We've got the first assertion of fact, which is that my motion containing a position maintaining an argument that I am... Wait a minute. Oh, my ex's motion containing a position that I'm only entitled to emergency care. The second is, I'm not even really sure if that's... I mean, I guess it's her allegation. That's kind of like a fact. But the next one here is that she's claiming harassment and that it would be better that we maintain an active but independent and separate role, which is kind of pointing to my recommendation to the court that we alternate or take turns taking the child to appointments. Third one here is that there's a no contact order in place. Fourth one is that my ex alleges that she's in fear and that this is contradictory, but it does further support the point that I'm making, which is that we should take turns at going to these appointments, scheduling these appointments, etc. The fifth is that she is claiming that I'm refusing to exchange our child, which isn't true. I'm not sure where that came from. Whatever, that doesn't go anywhere because I don't remember it. Sometimes there are things that come up that are kind of weird or alarming, but I don't remember them being an issue, which is a pretty strong indicator that the court didn't make a big deal out of it either. Section 2 here, which is the undisputed facts. The first one is that she admits there is a no contact order, which is kind of silly because the court could just look that up on the docket. And the second one is that she admits she's in fear, which is something that I'm taking advantage of to push for alternating appointments, even though I have argued that she has no basis for the fear, that nothing has really happened to her so that she should have any fear. I'm still going to go ahead and use her own statement against her to push the point that we shouldn't really be around each other anyway, even if it's false. The third one here is, the third section is issues, law, memorandum, which is basically points and authorities, statutes, rules, and case law, etc. So the first one, I'm just arguing that it's in the best interest of our child that we are both involved. Of course, I should be citing authority, but I'm not doing that. And that could be something like Rivero 2009, perhaps, maybe Mosley v. Figliuzzi, which is more focused on, the nature of high conflict. That's what that case covers. But either of those two, more likely Rivero would have been good to cite there. The second one is best interest of our child that we are both involved, and that us being unable to cooperate together, we should be able to alternate attendance at these appointments. Again, I should have cited Rivero. This is a great one to cite Rivero on because in Rivero 2009, they actually do have a very specific example that indicates to the courts, the lower courts, that they can give both parties joint legal custody, but order that one party has, let's say, for example, sole legal custody in the area of medical care, and the other one has sole legal custody in the area of education. And that's just an example to the court that, hey, this is a thing you can do. But again, I didn't cite it. I probably didn't realize at this point in time, back in 2010, the importance of citing statutes, rules, and case law, but that is something that I should have done. Next, we have here that the court has authority pursuant to, oh good, I cited a law, pursuant to 125C.010 to order us to follow the procedure outlined in the recent motion to set procedure for, and I'm kind of just referencing the procedure that I suggested or proposed to the court, and I'm indicating to the court that that law allows the court to order parties to follow a procedure like that. I really do question whether or not the law does allow the entry of a behavioral order like that. I know there's most likely something out there, 95% sure that there is something out there in precedent. I don't think there's a statute that says so, but I do think that there is some precedent by the Supreme Court of Nevada that allows judges to order what they call behavioral orders, which is just to control the behavior of the parties. I don't know the statute or the case off the top of my head. I just have a very strong suspicion that this is something the court can do. But I did want to indicate to my viewers that 125C.010 probably is not where that authority comes from. I'm not going to go and double check it because even if I do happen to be right on accident, which I don't think I am, the law could change anyway, or the statute could change, or at a later date something could happen where precedent is established that changes that. So I really do like to avoid telling my viewers precisely what to cite to get a specific outcome or to support a specific argument. That's definitely not what this channel tries to do, and I just want to reiterate that now. I'm trying to get everyone to think and to do their own research. I'm not telling everyone, or I'm not trying to tell everyone precisely what to cite when it comes to like an actual statute with a specific code number and stuff like that. Next paragraph here, or next page actually, is my affidavit, which is in support of the facts alleged in the statement. This is required by court rules, at least with regards to motions, oppositions, and replies. I'm not sure if it's required to be included in this statement, but I wouldn't be surprised if it was, because there are facts being alleged. The general rule of thumb is if you are alleging certain facts to have occurred, the rule of thumb is that usually some kind of affidavit is required so that the court knows that you are alleging those facts under penalty of perjury. And when it comes to law, everyone is just trying to argue the law in a way that's favorable to them. It's not the same thing as alleging a fact to be true. And so when it comes to just pure legal arguments, it wouldn't be a shock to me at all if you didn't need an affidavit in a filing that required, just points of law and stuff like that. Affirmation, which just tells the clerk of the court that this document does not contain a social security number. They will look for that signature, and, well, I should clarify, in Nevada this is required, or at least it was required back in 2010. I'm not sure if it's still even required today. I haven't looked into it because I just haven't felt like I had to. I think I still routinely include these in my filings just, to be safe, but I hardly file anything now. Probably in the last 12 months, I filed maybe two or three documents, and it didn't even have to do with this case. It had to do with stuff I'm doing with our Nevada judges. Scrolling down, we've got the proof of service, which is just, this should be a separate document. It shouldn't just be at the tail end. It's okay, you can do this, but it doesn't need to have, the caption and the title and all of that. Just it makes this look like it's a separate document that just got stuck to this one. That's why it's confusing. You could have just this little section right here from line 13 to 21 included on the last page of the previous document, and that's totally fine. That's what my ex's attorney's been doing since forever. That's what I will eventually start to do myself in this case, but I just think this is a little odd here that this document was just lumped in with the others. Going into the aftermath, I filed one document that is a free filing, so I incurred $0 in costs. My ex's attorney filed nothing, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. And I think it would be reasonable to say that to review this document and communicate to my ex what I was alleging in the document, at least with regards to the facts, maybe 15 minutes maximum. It's a very short document. It wasn't even, as far as I know, required, so there's a chance that she didn't even bother to look at it. Unlikely, she probably did look at it. And so I think with 15 minutes at the rate of $250 an hour, that's going to come to $62.50 in attorney fees. As for my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.